Council will allocate 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. My name is Mike Huey, and with me today is George Levesque, and Mr. Levesque will handle rebuttal. If we could reserve 5 minutes of rebuttal time, and Mr. Levesque will handle that.
So noted, Madam Clerk. You may proceed, Counsel.
Thank you. May it please the Court. We represent Northwood Associates, which operates the Northwood Mall. Many people know as the Northwood Mall. In 2004, the mall was a competitor in a competitive procurement through DMS and won that procurement. And that procurement was basically to convert the mall or to use the mall for the entire purpose of the state. It was some 400,000 square feet. There's a few outlying parcels, but basically it became a state building. And that state building included over 100,000 square feet of for technology space for the technology center to be located. So it had to be customized to take care of all the state's computers and what have you. The rest of it was primarily general office space that was configured to meet the state's requirements. In addition, and that was a 15-year lease per the state's procurement requirements. We negotiated that lease, and that lease required not only that Northwood would pay the tenant broker fee for the state, which was several $1 million, but that Northwood would also commit and pay $5.9 million to the state for tenant improvements, 3.9 up front at the beginning, and $1 million in staggered, two other staggered portions of the lease. And that lease went on until 2016. And in 2016, there was a proviso placed in the General Appropriations Bill, which prohibited the agency tenants from paying rent to Northwood specifically.
Counsel, is it your argument that we must look to the legislature's intent or motivation in determining whether the availability of funds proviso should apply?
Judge, I am sorry, I did not get your question. Is it your argument
that we must look to the legislature's intent or motivation in determining whether the availability of funds provision should apply?
Our argument, Your Honor, is that the availability of funds provision does not apply here. And as you will recall, the trial judge ruled that she was bound by your decision, solely bound by your decision in the Benson case. Now, the Benson case did involve a breach of contract claim by the Bensons who were leasing to the state, and the Bensons were claiming that the department violated its obligations under the contract by canceling the lease or sending them a notice of termination. The distinctions in Benson, we think, are clear, otherwise we wouldn't be here. The distinctions are that, and this court specifically found, that we were in a recession period. The department did not have the same number of employees, and in fact the state argued and gave you a litany in their briefs of what the reduction had been over years, and the specific lease appropriation for leases was specifically reduced, and this court noted, and the state argued in that case, that look, that's what the availability of funds clause is for.
Well, is that argument, though, a distinction without a difference? Because I believe in both the case before us and in Benson, there were actually funds in the expense pot to pay the Benson's lease, but the agency looked to the proviso language and determined what leases were needed and chose not to pay that lease and instead vacate.
Judge, first of all, the legislature did not cancel the Benson lease. The legislature put proviso language that said the agency is to determine where they have vacancies and is determine whether they have a continuing need or not. And secondly, the legislature did specifically reduce the lease appropriation, which we would contend the proviso goes to because that is the least identifiable fund, and it was a specific line item appropriation in the Benson case.
And what would be wrong if the legislature had decided to target that particular lease? I mean, yeah, I was reading with great interest the Southern Energy case where the legislature decided to specifically underfund a contract based on performance issues with the vendor, and this court upheld that as appropriate to do so.
It did uphold that. That was a breach of contract case. This is a constitutional case. In fact, the court made specific note that there was not a constitutional claim that they were deciding in that case, and made note of it that it's not a constitutional case. The difference is, in our opinion, the legislature has the right to fund. Okay, that's what they're charged to do. In our case, the legislature fully funded the agencies. That's undisputed. Fully funded the agency's continuing contract needs. Okay? What they did is they picked out this particular lease and they said, no funds are appropriated for that lease and you're prohibited from using any funds for that lease. And besides that, we put this proviso in other non-tenant agencies' budgets, and they can't use their money to go and procure anything at Northwood Center.
Well then, counsel, why should the legislature be forced to appropriate money for premises that, according to the record, were unsafe for state employees?
According to the record, they were what, Your Honor?
Unsafe for state employees.
Your Honor, I don't believe the record reflects that. In fact, I think there's a dispute on that. That was a contention. That was a contention that was utilized when the agencies went to the governor's office. But I think what happened here, and it's pretty well documented in the record, the chief of staff of the Department of Children and Families, not in testimony, but in a simultaneous email sent when this was being done, said, yes, we had language put into the budget that prohibits us from paying rent at Northwood so we can break the lease with impunity. That's specifically what the chief of staff, who, by the way, was part of all these planning meetings in the governor's office when they were planning out that they were going to go approach the legislature and put proviso language into the general appropriations bill during the last week of the session. So this was the plan.
Are you without remedy?
We're without remedy.
Aside from the constitutional issues, are you without remedy, or are you free to pursue? I know it was voluntarily dismissed, but I don't know, based on timeliness issues, if you could actually refile. Could you pursue a breach of contract, or could you have pursued a breach of contract action? We cannot pursue a breach of contract action if the availability of funds clause is used to stop this. That's specifically why they terminated our contract. They said the legislature put this proviso language prohibiting us from paying you. And that's in every contract. That's in every lease. That's in every state agreement of any kind.
Counsel, is it your position that there's no evidence in this record, either affidavit or otherwise, that shows that the premises were unsafe for state employees?
My position, Your Honor, is from their own expert. He testified there was no reason to vacate the building, okay? He testified if there was any reason to vacate the building, he wouldn't be there telling the employees what they were doing under the remediation plan with our client. The state didn't move. let me tell you what the state's remedies were under the lease, and it's clearly set out in the lease. They could withhold rent, they could cure anything that we weren't doing, or they could terminate. Those are the remedies of the state in this lease that they could take. They chose, and they never took those. They chose to go to the legislature and put proviso language in. Our contention is
When you say they chose, and I may have a misunderstanding of the record, but it's my understanding in the agency's LBRs, they asked for basically a continuation budget, and so it wasn't until the conference, when the budget chairs were meeting at conference, this proviso language was inserted.
that's exactly right.
Okay, so it wasn't as if the agencies were trying to thwart the contract. This was really a legislative decision based on my review of the record.
Legislative action can be the result of many outside influences. So yes, it was the legislature's proviso.
Right, and how does the availability of funds provision not give the legislature carte blanche to do exactly what it did in this case?
Your Honor, if the legislature can take over contracts which are competitively procured, which are negotiated for a term of years, and if the legislature can pick those out in any session, okay, and say, we don't like that contract, then what if they did that the second year into our lease? We would have been 2 years into the lease, we would have put up almost $7 million. Now the state says, oh, well, that's contemplated. I don't think that's what the availability of funds clause contemplates. The availability of funds clause contemplates whether the state has money to pay for the continuing obligations of the agencies.
And I understand the equitable arguments, but the funds provision doesn't have any of those caveats or disclaimers. It appears quite broad.
I understand their argument is quite broad, Your Honor, and I will tell you what this will ultimately do. It will, if you take that interpretation and say, well, that wipes out any impairment of contract, first of all, I don't think it can wipe out a single subject argument at all, because the proviso is unrelated in any way, and in fact, the facts show that the proviso was a hidden agenda, and it got transferred and became the legislature's hidden agenda in order to do nothing but prohibit the payment of this lease. But I will tell you under the impairment of contract and what this will do to state contracts. If you are going to tell all people who contract with the state that regardless of what we are seeking as a state, 15-year lease, we want to know we've got our employees there, we want to change the premises so that we've got them stabilized there and what have you, and we want $5 or $7 million up front to make sure that the premises are okay, then I would tell you, if you're going to say that's okay, please tell the public, tell the bidding public, that that's what that clause means, because I've been around for almost 50 years dealing with leases and what have you, and I can tell you the owners of these buildings and the people who contract with the state do not understand that their contract is subject to legislative approval or disapproval on a year-in, year-out basis. And they certainly don't understand that the people they're contracting with who sign a 15-year agreement with all those obligations and with remedies can go to the legislature at any point in time and walk away from that contract and use the availability of funds clause. Because if they can, we got nothing. You've got nothing. There is no contract if that's what it means.
Well, and I appreciate, your point is well taken, that Southern Energy did not present constitutional claims, but these same equitable arguments were made in that case, and this court rejected them flat out because of the availability of funds provision and because, the constitutional requirement, the legislature holds the purse strings.
Your Honor, I would disagree with you to the extent that the purse strings go to taking a specific contract and taking over the agency's authority because otherwise it undermines the Department of Management Services is clothed with the authority to go out, to do leases, to negotiate those leases, to set the terms, et cetera, et cetera.
Counsel, were these constitutional claims also raised in the Benson case?
These constitutional claims were raised in the Benson case, but in your opinions, or in, I believe you said on that case, Your Honor, in your opinion, you specifically said, look, the money wasn't there, they didn't get the funding, and consequently, that's what kicked in the availability of funds clause. Here, Your Honor, the record is clear. The money was there. The only thing that happened was, as described by this employee who was the chief of staff, is they had language put in that prohibited them from paying so they could walk away from the lease.
What relief are you ultimately seeking in this case?
What we're seeking in this case, Your Honor, is for you to say, hey, Benson is not controlling. And we further ask you to direct the judge that based upon Brown v. Firestone, based upon the Searcy versus Denny cases, that there has been an impairment of contract and that there has been a violation of the single subject requirements of the Constitution. But at the least, we are asking you to say, we did not intend the Benson case, which was a limited set of facts, where the legislature specifically underfunded a lease, and the Department of Corrections went forward based upon a proviso and examined its space needs and canceled that lease under the availability of funds clause, that's not the case here. We would urge you to take that into consideration.
Thank you, Counsel. Counsel, there are several appellees in this case. Has counsel decided whether or not they will split the argument, and if so, how?
Yes, Your Honor. Good morning. My name is Adam Tannenbaum. I represent the Florida House of Representatives. With the court's permission, the appellees ask that we be permitted to divide the time up 9 minutes for the House, and I will go first. Mr. Wenger from the Solicitor General's Office, representing the state agencies except for the Department of Education, would go next, 9 minutes, and then Department of Education is asked for 2 minutes at the end to address the court.
Thank you, Counsel. You may proceed.
Thank you. May it please the court. With all due respect, Northwood has it all wrong in this case. This did not take place in a vacuum, the events that they're describing. The agencies and the legislative staff in this case, in the legislature, acted in precisely the manner that we would expect state officers to act when employees are in a condition or working in conditions that are unsuitable, unfit, and unsanitary. Their response was quick, and it was effective, and it was done under an emergency situation. Had there not been action in this particular instance at the time that it was taken, the employees actually would have been doomed to stay in that center for another year under the same conditions.
Well, why wasn't this resolved via constructive breach of the lease agreement as opposed to through the appropriations mechanism?
Well, Your Honor, it's actually two sides of the same coin. And I will go back to what Mr. Huey had indicated in response to a question. The state's remedies, which Mr. Huey indicated, yes, withhold rent. That's a remedy. That's something they could do. They could cure or ask the Northwood to cure, and they could terminate the lease. In fact, that's what occurred in this instance. As of June 30th or July 1 of 2016, the agencies did stop paying rent, and by July 1 of 2016, the agencies vacated the premises. So the constructive eviction under case law, two things are required. There have to be unsuitable conditions, which the record, there's some fact dispute as to the nature of the conditions and how bad they were, but there is evidence in the record to that effect, including the story of Jennifer Gainey, who is a state employee working at her desk, and human feces falls and covers her head to toe while she's sitting at her desk because a pipe burst, covers the floor, and it took Northwood months, I think, to clean it up and clean the carpet up. There are reports of mold, endotoxins, and then, of course, the story of the bat guano in the ceiling above the Secretary of DBPR's desk. So you have those conditions, and those are facts in the record. There may be a dispute over that, but there is no dispute that that is the precise conditions that the Executive Office of the Governor and the Governor's Chief of Staff was reacting to, and then the Governor's budget staff going to the legislature and the appropriations staff there to act. Those are the conditions that they were reacting to. So yes, it is a constructive eviction situation. That's what the House argued in court. But what that gets back to, or what that highlights, is that ultimately this is a breach of contract case, not a constitutional case. So again, I respectfully disagree with Mr. Huey. This is a breach of contract or a contract dispute, just the same as Benson, just the same as Southern Energy, just the same as Cook, as a matter of fact. To get back to
Counsel, the
Yes.
House appeared in this case as an intervener. Is that correct?
the House is an intervener in this case, yes,
As an intervener defendant?
as an intervener defendant.
Okay. Well, how can we consider your challenge to the trial court's ruling striking your jury trial demand and affirmative defense when you didn't file a cross appeal in this case?
I'm glad that Your Honor asked that question. Northwood, I know Northwood made that argument in their reply that somehow we waived those challenges. Rule 9.110H sets out the scope of review for an appellate court on a direct appeal, and it's a plenary review. The case like Breakstone, for instance, that was a cross appeal. The cross appeal is reserved for situations when a party doesn't get the full relief under the judgment that was entered. So it's a cross appeal is a challenge to a component of the judgment that really didn't go that party's way. In this instance, the House and the other appellees got full relief. The summary judgment was full. It dismissed counts 1 and 2, or his judgment against those 2 counts, and knocked them out of court. There was full relief. So there was nothing for the House to cross appeal on because the House agrees that summary judgment was appropriate in that instance. The direct appeal of that summary judgment by Northwood was sufficient to give this court jurisdiction to review plenary all issues, including procedural issues like the striking of the jury trial and the striking of our witnesses and our constructive eviction and affirmative defense. The court, to get to those issues, would have to first determine that summary judgment was improperly granted in favor of the appellees, then would have to determine, which we contend, if that's where the court went, that there's still a fact issue that should be tried and that should be remand to do a trial on those issues, and not a remand with directions to grant summary judgment in favor of Northwood. If all that were to occur, it would be appropriate to correct what we contend are procedural errors that the trial court indicated, so that we don't have to take a third trip down the road to the appellate court to have reviewed the jury trial demand in that issue. So it would be appropriate.
Can I focus your attention on Benson?
Yes.
Because if that's controlling, then this case is easy to resolve. And the appellants point out that in that case, that did involve a budgetary cut to DOC's, I guess, their expense budget by about $1 million or so for leases. How is that not an important distinction with respect to the facts in this case?
Judge Ray, it's actually, as I think you indicated, it's a distinction without a difference. So in the budgetary process, and actually I should have said that's why I'm going first, is to address some of these legislative budgetary aspects. Mr. Wenger then will address things that I don't address, and Benson in more detail. In the legislative process, and this is a critical point, the agencies at the time, as I go back to March of 2016, I've already laid out some of the facts that were going on. In March of 2016, even Northwood indicates, and I don't think this is disputed, the agencies were already taking steps to try and relocate. They had already negotiated leases, and by middle of March, they've signed new leases, emergency leases as they're called, to relocate all these employees. But under budgetary law, and actually specifically 216.311 of the Florida statutes, that prohibits agencies from engaging in contracts or signing contracts that obligate them for expenses beyond what their budget authority was. So yes, Mr. Hugh is correct that under the expense category in this instance, prior to the proviso, there was sufficient appropriations to pay for all of the agency's leases at the time. What that also means is that there wasn't enough authority for them to sign a new lease or pay for a new lease on top of the Northwood lease. So what would have happened here is, without the proviso, without that avenue, the agencies would have, or the legislature would have had to appropriated double rent. It would have had to appropriate even more money on the expense category to accommodate the new leases on top of the Northwood leases. To get back to Your Honor's question about why that's a distinction without a difference vis-a-vis Benson, the proviso, the effect of the proviso here, was to provide legislative authorization for the agencies to do the relocation, and it did it by making budget room. So it effectively was a cut in appropriations. If you look at it from the perspective of if the agencies are relocating, they have a new lease which is over and above what their existing budgetary authority was. The proviso's effect is to carve out the appropriation of the expense for the Northwood lease to make budget room in the existing expense category so they could sign the new lease and do it legally.
So if the agency if they had not been taking these proactive steps to look for new space, to relocate employees, would that change our analysis? I mean, if we didn't have that as a factor in this case, and all we knew was that the legislature gave these tenant agencies the same amount of money in the expense pot to pay for its continuation leases, would we need to reverse under that circumstance?
No, those facts wouldn't be necessary, and the court freely could just affirm on the basis of Benson without the additional facts or what the agencies were trying to do to relocate. But the facts, sort of the context, does help, though, rebut Northwood's seeming contention that this was just a conspiracy to destroy Northwood. And in fact, Northwood was really beside the point in March of 2016. The focus of staff and the focus of the Executive Office of the Governor, the focus of the agencies, and the focus of the appropriations staff in the legislature were the employees in the Northwood Center that were suffering under unfit, unsuitable, hazardous conditions. And there may be a dispute over that, but that's what they were reacting to.
Counsel, do you think that the legislature here has unfettered discretion, or with respect to its use of these provisos, are there limitations? What would be going too far?
Well, going too far would be Lindner, the situation Lindner, the situation Lewis. Those are situations where the proviso language, and I'm sorry if I'm not answering, I think what the court is asking are there points when use of proviso in an appropriations bill would be too much or going too far, a violation of a single subject, for instance? Yes, and Lewis and Lindner are examples of that. When the legislature is trying to make policy through the Appropriations Act, using proviso to make substantive policy, that's going too far. If it's a restriction, which the legislature does have the authority to do under Brown, which is to put a proviso in to restrict the use of state funds, and is specifically limited to that, whatever the effect is, then the Constitution gives the legislature absolute authority to do that.
So there are no limits then, I mean, absent, writing new law or changing substantive policy, there are no limits on the legislature's ability to basically cancel multi-term, high-dollar contracts with state vendors for any reason whatsoever, unless they're going to write new law.
To answer that, I think to answer that question, if I could first correct the premise. I know that it started with Mr. Huey, and I don't want to concede the premise that there was a cancellation of the contracts in this case. Remember, the proviso did nothing to cancel the contracts, did nothing to change any of the terms, didn't direct the agencies to change the terms. It didn't change the amount of rent under the contracts, under the leases. It didn't destroy any of the remedies. It didn't change any of the remedies. The proviso here only limits the funds and says that that no state funds can be used to pay for the leases at the Northwood Center.
Counsel,
and yes.
Can the legislature indiscriminately target certain leases?
If it is using the proviso language and restricting funds and is limited to restricting appropriations, then yes. Because that would otherwise get into legislative intent, which I know that was asked initially. And this is not about legislative intent. It would be inappropriate to ask why is the legislature doing it and making a distinction between a proviso that is otherwise appropriate because it's limiting state funds, again, making a distinction.
You're all well into the other appellee's time.
I appreciate that, and I apologize to Mr. Wenger, and I thank you to the court for its time.
Good morning, and may it please the court. My name is...
And I'm sorry to catch you right there.
I am so...
And I appreciate the introductions earlier, but I know we have limited time, and I wanted to follow up on something Mr. Tannenbaum ended with, and that is that there's no impairment of contract because the rights of the vendor haven't changed here. But didn't we say in Benson that you can't sue for breach of contract because of the availability of funds clause? So what is the remedy, if there is one at all?
I think that perhaps the remedy would be an appropriately brought fact-specific breach of contract action. In that case, if there's any sort of concern about what the appellants have described as conspiracy, and we certainly dispute that anything of that ilk actually occurred here, they could actually bring and try to suggest that there was some sort of unclean hands argument. That, however, is just not this case. It hasn't been brought here. The only thing left at this point is the impairment of contract claim and the single subject claim. So there are remedies available. This isn't the type of situation where they're completely sort of up the creek, but this particular case is an impairment of contract case. It's their decision to have brought it this way and have argued it this way, and for reasons that aren't entirely clear to me, they've voluntarily dismissed their breach of contract claim. Now, I think it's very important to put that back into context, that here we're talking specifically about an impairment of contract claim. At the end of the day, what the impairment of contract claim turns on is whether or not the parties got what they bargained for. Now, as has been mentioned, in every single state contract that exists or extends beyond 1 year, the Florida legislature has made plain that there has to be a clause. We've called it the availability of funds provision, but I think that might be almost a bit of a misnomer. It says specifically that the state of Florida's performance and obligation to pay under this contract is contingent upon an annual appropriation by the legislature. So what that says is that every single party, private party that contracts with the state agency has an expectation that there is a condition precedent to the continuation of that contract going forward, and that condition precedent is an appropriation.
Counsel, I don't think I understand, though. Why should the availability of funds provision apply when lack of funds is not the reason for a no appropriation proviso?
Because in this case, to be very specific, Your Honor, there is a lack of funds for that Northwood lease. The actual proviso says very plainly that no funds are appropriated to go to the lease at this particular property. And the reason why I said that the availability of funds provision might be a bit of a misnomer is that that clause that goes into the lease is keyed into a legislative appropriation. So here, even though money had been allocated towards these state agencies basically having a home somewhere, the appropriations bill itself made plain that there was no money that was appropriated. So giving credence to the appellant's argument in this case to say that the legislature had to essentially defund all lease obligations entirely to trigger this availability of funds provision would lead to the rather absurd result that the state agencies would have been homeless. They would have had no money whatsoever to pay this lease.
I think the appellant's argument, if I understand it correctly, is that the availability of funds provision needs to be triggered by exigent circumstances, like, I'm going to use the term financial urgency or financial distress of the state, like happened in Benson. Otherwise, it really just gives the legislative branch unfettered ability to cancel multi-year, high-dollar contracts at whim. So how do you respond to that specific argument?
Specifically, Judge Ray, I think that goes to the point you made earlier, that those are interesting equitable arguments, but those are not impairment of contract arguments. Going back to Benson controls not only for the reasons that were discussed, but because the finding of Benson didn't turn on financial agency on behalf of the state. It's a very short opinion, and it turned on the existence of a proviso that the legislature put into the General Appropriations Act that said essentially you're not to spend any money that we are appropriating to you on vacant lease spaces. So you're right that those are interesting equitable arguments, but at the end of the day, as Mr. Tannenbaum had said, the legislature does have an awful lot of authority to appropriate money as it sees fit, and it would raise constitutional separation of powers concern if there was either executive or judicial interference with that particular process. So I know that I'm running short on time. I want to make sure that I've answered your question completely.
You have, and I appreciate that. I do want to turn real quickly to the single subject allegation, and in particular, how does the proviso language in this case not impact, let's use DMS for example, DMS's obligation to try to find another tenant, state tenant, to fill the shoes of this vacated space? I mean, clearly under these circumstances, they weren't going to put any state agencies in Northwood, so how has that obligation not been adversely impacted?
That particular obligation is conditioned on whether or not finding a new state agency to take over that lease is feasible. And for two reasons, it plainly wasn't in this case. The first, as Mr. Tannenbaum had discussed, there were serious health and safety issues that were related to that particular lease. But again, these state agencies are essentially bound to the money that's appropriated to them. And this proviso was put into the line item for all the state agencies across the board. So what the result of that was that no state agency could actually take over that lease because no state agency had appropriated funds to take over any of the leases at Northwood. That triggers the clause that's in the substantive law that essentially says that the only time that you need to find a new lessee to take over this lease is when it's feasible, and under these facts it plainly was not. So again, going back, the availability of funds clause is a statutory requirement that it needs to appear in every single state contract that lasts beyond 1 year.
You are into Appley Departments of Education's time, Counsel.
For that reason, we would argue that Benson plainly controls. Benson did not turn on the agency, and because it's precisely the same proviso here, it's precisely the same issue here. We would ask that this court affirm the granted summary judgment on behalf of Benson.
Thank you, Counsel. Counsel, we will extend your time by an additional 1 minute and 30 seconds. We will also extend the appellee's rebuttal time by an additional 1 minute and 30 seconds. You may continue, Counsel.
May it please the Court, Steve First on behalf of Pam Stewart as the head of the Department of Education. Our position on the validity of the proviso obviously is similar to the other appellees, and it's fully addressed in our brief. I do want to address one issue that was brought up by the appellant, and I will say that having practiced over 30 years with state contracts in both the private sector and with the state agencies. I can tell you a decision affirming the validity of the provisos is not going to affect the state's ability to lease. That provision is based on state law in Chapter 255, and I've cited in my brief. The law in Florida is if you have a lease over a year, you must include the non-appropriation clause in that lease. You must. A lease that doesn't have it is invalid. In addition, this lease did have the non-appropriation clause, and all state leases do. The lessors know that. This decision if you affirm the validity of the proviso, will not affect how the state does business. And remember, Pan Am Tobacco, which again is cited in my brief, which is just a 1980 decision. It's not that old. Prior to Pan Am Tobacco, the state had complete sovereign immunity for contracts, and it didn't affect the state's ability to do business. So this case will not affect the state's ability.
So, Counsel, did Pan Am waive the state's sovereign immunity in contracts?
In Pan Am Tobacco, for express written contracts. Pan Am Tobacco, prior to that point, because if you look at the history of Pan Am Tobacco, my recollection is the state won at trial. The state breached the contract in Pan Am Tobacco. They told the vendor, we don't want to do business with you anymore. And they won at trial, and they won at the first DCA. My recollection is at the Supreme Court, the court said no. The state, on express contracts, they can be sued for breach. Breach of an express written contract. In my case, with my client, there's no contract. So we can't be sued under Pan Am Tobacco. Which it goes to my original point, why is my client even here? Why are we sued? The trial court affirmed our summary judgment stating that there was a failure to state a cause of action. That's in the order of the trial court. That issue was not raised on appeal by the appellant. So I don't even think we're a party anymore. And again, I'm just representing the validity of our proviso. And that's why I filed the motion for attorney's fees. We're not even a party to this case anymore. We were dismissed, and the court granted our summary judgment based on failure to state a cause of action. Because we left the property at the end of 2009. We haven't been a tenant for 6 or 7 years. So when all of this happened, we weren't even a tenant. We had no contractual obligation to the appellant. Whether our proviso was valid or invalid, we're never going to know their rent.
Thank you, Counsel. Your time is more than expired.
Okay, thank you.
Your Honor, George Levesque on behalf of Northwood. I'd like to pick up where counsel left off with Pan Am Tobacco because I think that case is instructive. In that case, they cite unequivocally it is basic Hornbook law that a contract which is not mutually enforceable is an illusory contract. And we know that every contract that the state enters, one, must have this language, and they intend to enter into a contract. They contracted with Northwood for over 15 years before they decided to terminate this lease. So when it comes to the meaning of that, the question is, if the availability of funds clause means what the appellees say that it means, then it's an illusory contract. The state will never be bound by that.
Didn't we address that argument that, the availability of funds might create an illusory contract in Southern Energy, and we rejected it?
They addressed it, but they didn't address it in the terms of the Constitution. And here's where I think there is a distinction with Southern Energy and even in Benson. There were facts that were observable. In Southern Energy, the legislature made a policy choice to go in a different direction related to how it procures energy for that premises. It was a project that was essentially canceled. They went in another direction. In Benson, you had a budget shortfall where the legislature was scrounging around trying to make up the state budget, and they just didn't have enough funds. Somebody had to get the short end of the stick in that scenario. In this scenario, there are no such facts. The agency had a contract. It had the authority to use all of the remedies the legislation was not necessary. And when you look at the requirements, in Scott v. Williams, which was a pension case, the court observed that complete deference to the legislative assessment of reasonableness and necessity is not appropriate because the state's self-interest is at stake. And it goes on to say that a state is not completely free to consider impairing the obligation of its own contracts on a par with other policy alternatives. And there they were quoting the United States Trust versus New York versus New Jersey case, 431 U.S. 1, and then the Scott v. Williams case is 10 Southern 3rd 379. Now, what I'd note about that pension case is the court treated those cases, in the prior cases, based upon the funding of the pension system. Here, you were dealing with at-will employees who are participating in the FRS system. There is no sort of continuing obligation to employ those, so they will be entitled to all of those benefits on a year-by-year basis based upon what the legislature has done with its funding. Here, the state specifically asked for a multi-year lease, and they required upfront funds. They required that availability of funds clause to be put in there, and it's subject to appropriation. The appropriation here was actually made, as we've argued, and we think this is why it is different than Benson, because there's the appropriation, which is the legal authority to expend funds, and then there's proviso. The proviso acts to restrict that authority. The question is, that restriction, to the extent that it has been argued that, if it goes on to change policy, it goes too far. We believe that restriction does go too far because it does change policy. It changes the procurement laws. It means that Northwood is not able to participate in procurement actions that involve any of those enumerated agencies. And as the counsel for the Department of Education pointed out, they had the language and they hadn't been an attendant there since 2009, I believe it was. So the idea that this language was rationally related, and to go back to Brown, in Brown, proviso will be tolerated where it is determined that the appropriation is both worthwhile and advisable only if contingent upon a certain event or fact, or is the qualification or restriction being used merely as a device to further a legislative objective unrelated to the funds appropriated. Here,
so, counsel, it's your position that the proviso in question is not rationally related to the appropriations bill?
Yes, Your Honor, because I believe what it does is it is intended to do something that other statutes ought to already address, and that's the procurement of lease space. Here, it's intended to interfere with that process and rule Northwood out for any participation in the procurement process for certain state agencies. And I see my time is up.
You may remain, counsel. You may ask a question.
So if we were to write an opinion kind of defining the availability of funds clause or putting a scope on that, what would that opinion look like? What would that holding be? In your opinion, when does the availability of funds clause apply?
I believe it applies in exigent circumstances where the state has gone through the process of making that determination. Here, there was nothing in the legislative process that would have indicated that.
And what do you mean exigent? Exigent financial circumstances, or what?
I believe actually it could involve policy choices. Say, for example, assuming all other things being equal, the state wanted to do telecommuting for their work. They could have said, you know what, we're getting rid of our leases and all of our state employees will work from home from now on. And they could take those funds and redirect it. Now, I think in that scenario, you're probably going to have substantive legislation that goes through the process that will mirror that. But I think in that scenario, the legislature is making a deliberate policy decision to go in a different direction, and they're reallocating the funds away from that. Here, they reallocated them for the same purpose.
And would we be rewriting the contract if we included that limitation, that is, availability of funds subject to exigent circumstances?
I don't believe so. And it goes back to, if it means what they say it means, if they've got carte blanche to cancel everything, then it's an illusory contract, and you can't adopt an interpretation of a contract that would make the contract meaningless.
Thank you, Counsel.